Good morning. Happy Wednesday. A viewer sent me an email with 5 million different questions about the Springer versus was it the 6th Judicial District Court, 7th Judicial District Court, whatever it is. Uh, so rather than write an essay back or a memorandum of law, which would be more appropriate, I decided I would do a video. That means if anybody else has any questions on these things, maybe this will answer it. So the big issue in Springer, his attorneys have filed a response to the order to show cause. I have not had an opportunity to review it yet. I'll do it live on stream. Hopefully tomorrow, if I'm in a mandatory settlement conference, theoretically all day, but I don't think it's going to be something that's going to be able to be resolved. So if I get out early, then I should have time in the afternoon tomorrow, Thursday the 16th, to go over it. Otherwise, it's going to be not this weekend, but probably next weekend that I'm going to have an opportunity to go over it. But be that as it may. So the big issue is, I understand it, having read the judge's order to show cause, what was it, last week? The big issue, as I understand it, is James is suing judges. Judicial immunity may apply. But to start off with, there's two ways that you could sue under 42 USC 1983. One is you sue the person in their individual capacity. You're saying that you, specifically you, violated my rights and I want money. That's what suing in the individual capacity is. You sue to get money. There's also official capacity. So if you sue someone in their official capacity, like if you sue the Attorney General of a state in his official capacity, or if you sue the sheriff, what you're saying is, like, you specifically didn't do anything, but the state, through your office, in your official capacity, you've promulgated a rule, a law, whatever, that is unconstitutional, that violates federal law or the federal constitution. And I want declaratory relief or injunctive relief, things along those lines, right? Because you get declaratory relief or injunctive relief from an official capacity suit. And the declaratory relief would be that that law, that rule, that policy was unconstitutional. Or injunctive relief would be where the federal court says the state can't enforce this law, rule, policy because it's in violation of federal law or the U.S. Constitution. So that's the difference between the two. You could only you pick one or the other. I guess technically you could sue in the individual capacity for money and in the official capacity for declaratory and or injunctive relief, but you got to kind of call it, right? You have to say how you're suing. You can't just say I'm suing you under 42 USC 1983. You have to say I'm suing you in your individual capacity, I'm suing you in your official capacity, or both, right? So James Freeman's, Springer's lawsuit says that he is suing the judges and their underlings in their individual capacity. The problem is that your only remedy is money, and 42 USC 1983 exempts judges from being sued for money. You could only sue a judge for declaratory relief. So you can't sue them in their official capacities or individual capacities. And judicial immunity, the theory of judicial immunity would also come into effect if you're suing them in their individual capacity for money. And so you can't get the declaratory and injunctive relief in the individual capacity suit, and judicial immunity prevents you from getting money. So he says individual capacity, so that's a problem. You can't get what he's asking for, and you also can't get what you would normally get from an individual capacity suit. Now, on the other hand, is the official capacity suit. You're saying that the judge, in the judge's official capacity, has made a rule, law, policy, whatever, that violates the Constitution or federal law. And so normally in an official capacity suit, you can get declaratory or injunctive relief, except the Judiciary Act of 1996 has changed it. So if you're suing a judge, all you can sue for is declaratory relief, unless declaratory relief isn't available, and then you can go to injunctive relief. So basically what you have to do is you have to sue for declaratory relief. If the court then says that yes, this rule, law, statute, whatever is unconstitutional, if the judge does it again and violates that and basically goes against that declaratory relief and says, F you, I'm going to do it anyway, then you could go for injunctive relief. But that hasn't happened, right? So Springer is suing for declaratory and injunctive relief. That's what he asks for down in the body. He also asks for attorney's fees, which again, it's hard to get attorney's fees from judges. He doesn't say who he's going to get the attorney's fees from, but it's hard to get the attorney's fees from judges. They have to basically really screw up and act in complete violation of their position, yada yada. So it's hard to get attorney's fees out of judges who are making orders as judges, who are acting in their official role as judges, not outside of their judgeship role. So he's only entitled to declaratory relief, but he's asking for a preliminary injunction and injunctive relief. So if he sues in official capacity, he's asking for things that he can't get, specifically the preliminary injunction or temporary restraining order and an injunction. So the problem with a temporary restraining order and injunction, number one, is the 1983 doesn't allow you to get that relief unless declaratory relief is not available or the judge is ignoring a previously issued declaration by the court that the action is unconstitutional, that statute or whatever that the judge is trying to do, the thing the judge is trying to do is already unconstitutional. The next issue is that because it is a order of the court, the Rooker-Feldman doctrine is going to come into play. The Rooker-Feldman doctrine is really simple. It's not overly complicated. It just says that no federal court lower than the United States Supreme Court, so the courts of appeal, the circuit courts, and the district courts, the circuit courts and the district courts cannot act as appellate courts for the state. They can't review state court decisions and basically overturn them. They can't act as courts of appeal, which, it was stupid when Eline was saying that that Chile was going to appeal to the Ninth Circuit federal court. It can't do that. That's specifically what the Rooker-Feldman doctrine says can't happen. And the reason why the Rooker-Feldman doctrine comes into play is because the states are sovereign. They are their own individual entity, and the lower federal courts can't make state law. And they have to look to what the states have determined is their law and how the states have interpreted their laws to figure out how to enforce, like if there is a state law issue raised in federal court, the federal court has to use how the states have interpreted it to work it out. So the Rooker-Feldman doctrine is going to be a big issue. Now, the other big issue is that in his First Amendment complaint, or is it? Yeah, it's his First Amendment complaint. Springer has characterized the orders issued by the court as unlawful. And this is going to sound silly, but follow along. If you're suing a judge in the judge's official capacity, you're saying that the judge has made a law, order, whatever, that is unconstitutional. But if you say that what the judge did was unlawful, then it's not state law. And so the official capacity doesn't work. Technically, if a police officer did something unlawful, acting under color of law, you sue in the individual capacity. You say that's unlawful. Money, please. In an official capacity suit, if you say what they did was unlawful, what they did in their official capacity violates state law, then it doesn't work. You're asking the court for declaratory relief that what you're saying is unlawful is unlawful? It doesn't make sense. It doesn't work. There's case law on it. It's a difficult concept. I can't really explain it well, so I apologize about that. But that's going to be another issue for the official capacity suit. So basically, either way he goes, because of judicial immunity. So because of judicial immunity, he has to go official capacity suit, which means all he would be entitled to at best is declaratory relief. But he's going to have to get past the Rooker-Feldman doctrine, which is a problem. And he can't characterize it as unlawful. So he's in a rough situation. He's in a rough situation, which is why when C.J. Grisham talked about suing a judge, I was like, whoa, buddy, good fucking luck, right? You know, when Springer sued a judge, I was like, whoa, buddy, good luck. I mean, it is very hard to do. It's very hard to do successfully. I'm not saying it can't be done. There are specific situations where it works fairly well. If, for example, the judge did something that was completely outside of the realm of what judges are allowed to do. Like if a judge goes to someone's house to make sure that they're complying with a restraining order, that action or injunction, that action is outside of what a judge is supposed to do. So you can sue the judge in their private or in their individual capacity for money damages and be just fine. If the judge does something in their administrative capacity that instead of in their capacity as a judge, then maybe you can get past it. But if a judge does something as a judge, your recourse is to appeal it. Your recourse is to go to the Court of Appeals. Whatever that court is to get relief from what the court you were in did, you go to the Court of Appeals. You appeal the decision. Or if appeals aren't available, you petition for a writ of mandate or a writ of prohibition. A writ of mandate says, okay, lower court, you've got to do this, so do this. A writ of prohibition says, lower court, you can't do this, so don't do this. An appeal says, court, what you did was wrong, so either I'm overturning it or I'm remanding it back for you to do it this way or what have you. But that's what James's actual remedy was. It was an appeal. It wasn't to go and file a lawsuit against the judge, a 42 U.S.C. 1983 lawsuit, which, I mean, what has been established is that James Springer was notified of these particular orders. So he had notice, he had an opportunity to go and appeal. Now, if the time has passed for him to appeal those orders, well, that's a real problem. That's a real problem. Because normally you only have a certain amount of time to do it. And he's been dicking around in federal court for how long now? So, appeals, I don't know how long it is. I can't even guess. But generally speaking, my understanding is that appeals generally have to happen within a certain amount of time from the date of the entry of the final order. So those orders were back in 2023. I mean, we're halfway through 2024 now. It's been a hot minute. He might have screwed himself there. But anyway, that's the long and the short about the problem with Springer's lawsuit, at least as far as I understand it. Again, I will go over Springer's attorneys might have come up with some magic. I don't know, but if they did, it would be unusual, to put it mildly. Nothing that they've done is magic so far. And I can't also wait to see the response from from the other attorney on the other side, the one representing the judges, because that attorney has been a complete clusterfuck. You know, if the court has to be like, hey guys, excuse me, no one's brought up these issues, and so I'm going to make you bring up these issues because these are the obvious issues that I can see. These are the issues that a first-year family law attorney out of California could see, who doesn't even practice in New Mexico, and he's over here screaming, judicial immunity! Oh, it's stupid. Anyway, you know, I lose more and more faith in the legal profession every day. See, in court, it's different. Like, if I was dealing with Eli in court, I'd be like, well, you know, he's getting paid to represent his client. And his client doesn't have a good case, so he's going to make whatever arguments he can make, and God bless him, that's all he can do, right? He's getting paid to represent his client. He's going to represent his client. He's going to use whatever he can do to represent his client, because that's what you have to do. That's what you get paid to do. Outside of court, if you're making the same stupid shit, same stupid statements, like soliciting the crime of trespass is a crime, blanket statement, full stop. If you're saying that shit outside of court, it means either you're completely, or if you're saying that Chile is going to appeal his district court appeal resolution to the Ninth Circuit Court of Appeals, completely ignoring the Rooker-Feldman doctrine. If you're saying stuff like that, it means you don't understand what's going on, or you're lying, or both. I mean, there's not a lot of room for, so I get real frustrated. But then when I see two sides arguing in court, like Springer's attorney should never have brought this suit. Springer's attorney should have been like, you know, James, how about we fucking appeal? Because that's really your remedy here. Your remedy is an appeal. So I don't understand what the fuck's going on there with him. And on the other side, the other attorney is like completely talking about qualified fucking immunity. Like, bitch, like, whoa! What the fuck is wrong with you? Oh, you're being a anti-woman. The judge who issued the order to show cause, I don't know if she's a judge or a magistrate, but she's a woman. She's smart. I have been thoroughly impressed with the federal court judges. The one on the DeCastro versus Abrams, female judge, incredibly smart, handled everything, as far as I could tell, perfectly appropriately. But this Jay Delphine, I mean, I don't know what's going on in New Mexico, bro. I don't know what's going on in New Mexico. Like, what's going on? Anyway, they got good judges, apparently, or at least they got good federal court judges. I still want to know, if what the state court judges did in Springer is an appropriate action. And I don't think we're ever going to get that resolution because James Springer and his attorney have, like a monkey fucking a football, they've screwed this up. We're never going to get resolution. You're never going to get that moment if you're a monkey fucking a football. Ain't going to happen. So, anyway, that's my 2 cents. Thanks for watching. I might see you tomorrow. Might not. We'll find out. Have a good day.